The topic of wills is always hotly contested. Maybe you're feeling that you don't need one, or maybe you're unsure about the one that you have and whether the information is appropriate. Perhaps you're concerned about asking a silly question. Well, today I'm going to be asking all of these and more. I'm here with Jayshree and Rohit Gordon, directors of one of our country's leading administration companies, Legatee Trust. So why am I hosting them on the show? Two reasons. The first is skills. Jayshree obtained the following qualifications: a diploma in estates and trusts, BCom degree, advanced diploma in estates and trusts, postgraduate diploma in business management, and an MBA degree. She's also a registered fiduciary practitioner of South Africa. Now, she's administered over 1,000 estates and been an executor to over 5,000 estates. Rohit has completed his LLB and he's been a senior specialist practitioner at FNB. He was then promoted to senior business development consultant in estate and trust administrations. In 2012, he was headhunted and appointed as the national head of business development. Then he was promoted to national head of beneficiary solutions. So they are both highly qualified and experienced. And the second reason is that they are among the rare breed of individuals who are so passionate about helping others and working at the highest level of integrity. Rohit, so share with us, what is a will?
So will is a set of instructions provided by someone in terms of how they would like to leave their assets to their loved ones when they pass away. For example, if you've got a house or you've got a car, you can create a will or have a will drafted and give those to your loved ones or your beneficiaries or next of kin.
Right. So Jayshree, why is it important for us to have a will?
It's probably the most important document you will ever sign during your lifetime. And if you want the opportunity of choosing your who your assets go to, drafting a will is the most crucial document for you to start off with.
Okay. Jayshree, what happens if we don't have a will?
So when a person dies without a will, their estate devolves in terms of the Intestate Succession Act, which means in terms of the South African law, it goes to your next of kin in certain proportions.
Okay. So that would mean family members may inherit where we did not want them to inherit.
Correct. It's one of the main reasons that we encourage people to do wills. You then decide when you draft your will which assets goes to whom.
Okay. And what would you say is the percentage of people that actually have wills in place?
Well, currently, according to most stats, 75% of South Africans do not have a will.
As much as 75%, that is alarming.
Yes.
And why is that?
You know, there's probably a lot of myths out there, a lot of people that do not understand the importance of a will, a lot of people that don't understand what happens when you don't have a will. So because of those reasons, people have not drafted one. Many misconceptions that if you just have a bank account, you don't need a will. So some people link your asset value to having a will and not having a will. So there's various reasons.
Okay. And what would be some of the first steps for drafting a will?
So the first step is obviously to decide in terms of your assets how you would like to bequeath them to your loved ones. You can then contact a professional institution in order to assist you with the drafting of your will. It's a fairly simple process. You complete a will application form, and at Legatee Trust Services, we draft the will within 24 hours, and it will either be emailed to you, or alternatively a consultant will call you and take you through the clauses or assist you in signing the will.
Okay. You mentioned getting a professional, but is it important to have this professionally drafted?
Well, you can draft your will yourself. It is always recommended that you seek advice first, and there's various reasons for that. Yes, you can simply go and handwrite your will and say you're leaving asset one to your spouse, but there's important clauses that a will must have. Your will has to be clear, not vague. You have to include clauses like a protection of beneficiaries, your collateral clauses. There's various clauses that are crucial in your will. So it is always recommended that you seek advice, and it's preferable to have a professionally drafted will, and they are relatively inexpensive. In fact, Legatee Trust drafts wills for free.
So in terms of the Wills Act, there are a number of certain mandatory requirements that need to be met in order for your will to be legally valid. Some of them are: the will has to be dated, it must be signed by 2 witnesses, each page must be signed by the author of the will, and the will, as Jayshree mentioned, the will must be clear, concise, and in writing.
Okay, so what happens in cases where one of those items are not done? Would that mean that the will is invalid?
So in certain cases, yes, the Master of the High Court can declare the will invalid, but there are certain mandatory requirements that if they are not met, the will be declared invalid.
Okay, but I'm assuming that all of that takes time. With the family going through a lot of struggles already, it would probably take time for the master to make a decision whether this will is valid or not.
Correct. Therefore, going through a professional institution, they will ensure that these clauses or requirements are met for the will to be valid, and evade circumstances where the master will declare the will invalid.
Yes, and at Legatee Trust Services, we go above that. So once a client's will is dispatched, they sign it, it's then sent back to us, and a legality check is done to ensure that they have signed it in accordance to the Act, that it's dated, so that before we put it into storage, we ensure that everything is being complied with.
So you mentioned that there's certain requirements in order for a will to be valid. Share with us a bit more about those.
So the will has to be dated in terms of the Wills Act. It must be signed by 2 witnesses on each page. The author of the will needs to sign every page. The witnesses cannot inherit in terms of the will. The witnesses cannot also be the nominated executor in the will. So those are some of the requirements that need to be adhered to in order for the will to be valid.
Okay, so that's pretty intense. Let's just assume I forgot. I didn't sign my will or I didn't date my will. What happens in that case?
So it can be ghastly in terms of the consequence of who will inherit. It can also declare the will invalid or partially invalid. Therefore, ensuring that those requirements are adhered to will meet the requirements of the Wills Act and therefore be a valid will. So, in summary, not adhering to one of those requirements can declare the will to be invalid or partially invalid, obviously determined by the Master of the High Court.
Right. And if it is the case, what does that mean if the will is invalid?
So it does mean that your will is invalid, and then your estate will devolve in terms of intestate succession. So it's the main reason why we recommend that you seek advice, and preferably to draft your will professional.
So let me put it to you this way, Devin. For example, if you intended your mum to inherit from the will, and you haven't dated or you didn't sign each page, and the will is declared invalid, as Jayshree mentioned, in terms of the law of interstate succession, a far cousin can inherit, your nearest blood collaterals whom you never got along with, your relatives who you've never spoken to, in such instances can inherit. And it's obviously not the true intention of the individual who you wanted to initially bequeath from the will. So therefore, not adhering to the mandatory requirements, as I've previously mentioned, has a consequence of individuals in potentially inheriting that you wouldn't want during the time of your life.
So can you give us an example? What would happen, or a practical case study where a person had, whose will was declared invalid?
So unfortunately, when a will is declared invalid, the family don't take kindly to that, because they were obviously expecting X, Y, and Z from the will, and when the master declares it invalid, that at the start just already creates issues with the family alone. The process itself is not changed too drastically. The cost could be a little bit more because you then have to get a bond of security to get the executor nominated. But it does create issues, and we cannot now, once a will is declared invalid, still fulfill those wishes, because if I gave Devin a motor vehicle and now that will has been declared invalid, Devin is insisting he wants his motor vehicle. But in terms of the interstate succession act, you probably are not going to get that vehicle. So it does create a lot of family feuds, a lot of confusion and frustration for the family, because they knew what the testator intended, but fulfilling that now is just not possible.
So the delays could come in where the initial beneficiaries of the invalid will would bring a court application to the High Court, where they would then declare that either their dad or mum who had passed away would have wanted them to inherit. In certain cases like this, perhaps now that it's invalid, the Interstate Succession Act applies, and maybe an illegitimate child would now be inheriting, which the other beneficiaries don't want him or her to inherit.
And that does delay this process, because a High Court order alone, you're looking at probably a 6 to 8 month extending the period. So the executor has to wait for the outcome of that High Court order before they can proceed with the administration process.
Yes.
So there's a lot of ways that an estate could actually end up if a will is declared invalid. And it's just an unnecessary burden on the family. You rather just go to a professional, draft your will, and ensure that your wishes are being fulfilled.
Okay. So we speaking about this word estate. What exactly is an estate?
So in estate, a simple answer is on death what you own. So it could be properties, it could be vehicles, bank accounts, investments. That's all inclusive in your estate, and it also includes your liabilities as well.
Okay. So the estate does not include policies where you have a nominated beneficiary. It will only include policies, shares, unit trusts that is payable to your estate upon death. Like Jayshree mentioned, shares, unit trusts, investments, property, vehicle, cash, Kruger coins, which form part of your estate.
So all of this is sort of pooled together, and then we're calling that the estate.
Correct.
Perfect. Okay. Let's assume there's a single individual with no kids who needs to draft a will. What are some of the things they need to be mindful of?
So it's very simple. One needs to look at the type of assets that they have and ensure that their loved ones or their friends or whomever they wish to inherit to utilize the will to bequeath it to those individuals.
Okay.
But our recommendation is generally for any individual to seek financial advice first. The first step is obviously engaging a financial advisor, and the second step is doing your estate plan, the third step drafting your will.
Correct.
Okay.
So following those steps are quite crucial, because that gives you a holistic view of what you could do and what you want to do, and then meet in between.
And then assume this person marries, like a year or two later they marry. Can they go back and amend that initial will?
Yes, 100%. And we highly recommend that in circumstantial changes in your lifestyle, should you buy a property, should you get married, maybe own a business or start a business, it's important that one regularly amends or reviews their will in accordance with their lifestyle and changes thereof.
Okay.
All our reviews at Legatee Trust, so it's unlimited and they're all free. So every time that circumstances change, it's crucial for you to change your will.
That's quite important, because life happens so quickly. So it's nice to be able to know that clients can come back to you and make those adjustments.
Yes.
So we know that if a single person starts off, marries, they can adjust the will. What happens in the case of divorce?
So in the divorce, one needs to ensure that the will is timelessly amended to ensure that if the individual does not want the ex-spouse to inherit, that you approach Legatee Trust or professional institution and amend the will timelessly. It's important to note that where minor children are involved, that the guardianship is nominated in terms of the biological parent and not a family member, as in some cases that we see.
Okay.
And what's also very important that's linked to that is that once you divorce, there's obviously in certain circumstances a divorce agreement. So your will must speak to the divorce agreement, and all of it must obviously link up to your will. You can't have one contradicting the other.
Correct.
Okay. And then let's assume again there's a couple with 2 kids. minor kids, what are some of the things that they need to be on the lookout for?
So, in a lot of cases that we note, individuals, parents like to leave assets to their minor children, and obviously, minor children can't pay rates and taxes, electricity. So, where individuals are bequeathing property, for example, to their minor children, it's important to utilize the testamentary trust as a tool to ensure that the executor or trustee, rather, manages the asset on behalf of the minor beneficiary. Now, what's nice about a testamentary trust is you can nominate a specific age or dictate a specific age where the minor beneficiary can then obtain the asset. What's nice also about the testamentary trust is you can do it in parts if it's cash, where you can give 50,000 Rand when the minor beneficiary turns 21 and perhaps another 50,000 Rand at 25. So there are ways and means where individuals have children that they can use the testamentary trust to the benefit of the child and the parents.
Yeah, and it's a tool that obviously accommodates for you paying their education needs, medical needs during their lifetime until they become majors. So it is quite a helpful tool, and done properly with a financial planner, it can actually ensure that those assets are still there once those children become majors and they can benefit from it.
Okay, so just from my understanding, a testamentary trust, is that set up whilst the person is alive, or is this set up only when the person passes away?
So a testamentary trust is created once the person passes away, and it's created via a will.
So you don't actually have any costs whilst you're alive for setting that up?
Not at all.
No.
Okay.
It only comes into effect on death.
Correct.
Okay. And that's there to take care of kids who are below 18? And I'm assuming there's trustees still to oversee and make sure that everything's working according to plan.
Yes, 100%. So testamentary trust can also be utilized for majors. For example, hypothetically speaking, you've got a brother who's an alcoholic or gambler, drug addiction. You can use the testamentary trust by way of bequeathing assets to him and using that tool to stagger your inheritance to him. So let's say, for example, you don't want him to inherit the entire capital, you can stagger it in certain stages during his or her lifetime.
Okay. Now, there's so many companies getting wills done. You can have this drafted at banks, there's many other estate planning companies. What makes Legatee Trust so unique?
So it's all about our bespoke service, customized offering, face-to-face meetings. Nowadays we do it virtual. We've got consultants who regularly contact our clients and ensure that their wills are kept up to date. And it's all about turnaround time, service, and communication, ensuring that the communication lines are kept open, not treating your client like a number. We noticed that in some cases, what happens in the industry, the client would draft the will, and that's it. That's the end of the relationship between the institution and the client. Now, with Legatee Trust Services, we have a policy where the client comes first, and we ensure that communication lines are kept open throughout the client's lifetime. Regularly contacting the client to amend wills, reviews, ensuring that documents are kept up to date, and so forth.
To use an example, we recently had a client that literally reviewed his will within a 2 week space of time 10 times. We consulted with that client 10 times. All those consults are free. We eventually got to a space where we drafted the will that he was comfortable, he had peace of mind, he was satisfied in terms of the wording. And all of those consults, the telephone calls, the back and forth, it's all free of charge. So there's no cost in drafting a will. We don't charge to store your will either. So it's adding value to the client at the end of the day, and it appears to be working.
Okay. I like, in particular, the option of being able to do this online. I saw that on your facility. So walk me through that.
So a client can at any time log on to our website. There's an interactive will application form. Client completes the will application form and sends it to us for drafting his or her will. The will is drafted by our drafting team, dispatched within 24 hours, and the client has a will. Well, obviously you need to sign it and then send it on to us, or we can arrange for a collection of the client's signed will, and then, as Jayshree mentioned earlier, it goes through a vigorous legality check to ensure that the will is valid, it's in accordance with the Wills Act, and the mandatory requirements are met. So a face-to-face meeting may never be needed between us and the client to ensure that the will is valid and the will is in place.
Okay, that's extremely convenient.